Welcome, sir.
Please.
Sir, Advocate Karthikeya from All Gujarat Federation.
Ji.
Dhruvin bhai?
Yes, Sirji. Sirji, welcome.
Shall we start?
Just a second, huh?
Sir, તમારે PowerPoint presentation કેવું છે?
No, nothing.
Dhruvin bhai start કરીએ?
Yes.
Friends, welcome to today's very interesting webinar subject, that is alternate dispute resolution. Remedy except the litigation. Friends, we know that now the era of litigation has arrived, but sometimes we have to accept the fact that every matter or every issue cannot be solved by proceeding for litigations. It takes number of years and patience to complete the whole litigation issue. So if we adopt a shorter way and a better way in the form of alternate dispute resolution, either mediation, conciliation or arbitration, it will definitely suffice the purpose and it can be termed as out of court settlement. Friends, we have an expert authority, Advocate Paras Sukhwani, who is expert in this alternate dispute resolution matter line, and he has dealt with many matters for that. We thank CA Ashish Sukhwani for bringing his honorable expert on the platform of AGFPC and IT Bar. I request President of Income Tax Bar Association, Shri Dhruvin Mehta, to give his brief speech.
Thank you, Karthik bhai. First of all, I welcome all the participants and also our today's eminent speaker, Advocate Paras Sukhwani ji. Today's topic of discussion is alternative dispute resolution. ADR often saves monies and speeds the settlement. ADR works which saves times in litigation and have win-win situation in all the related parties, and that is also beneficial to government as pendency of cases are so many in the court, so it will reduce the litigations in courts and speedy justice to the parties. So that is also good for the government. So sir will brief us how ADR works and how as a professional we can work on this line. So sir, again I welcome you.
I begin my address with a thanking note to our popular President Shri Karthikeya.
Just a second, I want to introduce you. This is our tradition. So Advocate Paras Sukhwani is a advocate. He is practicing principally at the Honorable Gujarat High Court, specializing in the field of arbitration, contracts and tender matters and family disputes, appointed as court commissioner by the Honorable Commercial Court at Ahmedabad. He has appeared and conducted cases before more than 7 different Honorable High Courts. He has conducted live TV program on Doordarshan for maintenance and welfare of senior citizens. He is devoting lectures as visiting faculty at LJ School of Law. So friends, we feel proud to have amongst us the most expert and most learned faculty. So please welcome Advocate Paras Sukhwani. Thank you so much, sir, for accepting our invitation.
I begin my address with a thanking note to our popular President Shri Karthikeya ji, Shri Dinal ji, Mehta ji, Sridhar ji. Now, as lawyers, we are all aware of how the court functions. Not being sarcastic here, but we are aware of the process that first we take up the case, we may issue a notice. The notice, if the party is a government, it's a 30-day notice. After that, we file a plaint. Plaint comes up for hearing. If the court is convinced, the court may issue a summons, written statement, cross-examinations, depositions. Now, this is a process, more or less we are aware. And more or less we as lawyers are prepared that this much time is required. And in all fairness, when other side advocates request us that I might need 15 days for a reply or 20 days for a reply, we normally have no objection. Now that's something we call as professional ethics, professional etiquette towards our brother lawyers. At the end of the day, at the bar, we are all brothers, right? We address each other as brethren. So there is some meaning to it. There is some respect. So as a mark of respect, we normally don't disallow the request of our other side when he is asking for time. પછી reply માટે હોય, પછી summons માટે હોય, પછી additional evidence માટે હોય. But imagine a legislature, imagine a statute, imagine a dispute resolution process which has a stipulated timeline for these things, which has a time adherence to it, and if that adherence is not followed, it will invite consequences. It will invite problems, and specifically problems for the party who is actually gaining that time. We see now that there are amendments to the Commercial Court Act also to have a stipulated timeline. But today our address is focused on alternative dispute resolution. I'll not bore my learned friends by taking them to the process of the court and explaining them what a written statement or a reply is. So pardon for that brief introduction of the court. But what do we mean by alternative dispute resolution, ADR? My learned friend here beautifully explained the three major mediums of arbitration, mediation, and conciliation. Today, we focus majorly on arbitration, mediation. Conciliation is something which we more or less are involved in an informal process, which our clients normally take up on their own. Conciliations and negotiations, they don't even realize, but it is part of a legal process which they undertake. Sometimes a statutory body is monitoring them, sometimes without it. But our parties sometimes are more smarter than us in that sense. કે જો સાહેબ પાસે જઈશું તો પછી આટલો ટાઈમ લાગશે એના કરતા તો આપણે જ સમજી લઈશું. Right? We all as lawyers, I believe most of the attendees and participants here are majority lawyers. So I'll address you also as brothers. We all brothers have sometimes come across clients which sometimes we figure out are already Google-based lawyers, half-baked lawyers. They come to us by saying that, sir, apply this provision and get the result now. And we'll tell him those Google egos and shoes outside my office. Right? So in this era of modern litigation, how do we explain the person who is expecting a result that this is a better process? To answer that, let me take you first to a professional ethics quality which I personally have inherited from my seniors, that we cannot guarantee a result so far as litigation is concerned. Nobody can. Not even a judge can say that this is a bound result of this particular case. Every case is different from the other. Every factual nuance, every factual evidence, every circumstance may differ. We don't know. We don't know on what point the court is convinced and on what point it may pass an adverse order. We don't know. This reminds me of an instance which had happened years ago, and time and again we have been witnesses to such instances, that a senior advocate with full force argued a point before His Lordship Justice A.M. Ahmadi. And we all know Justice Ahmadi's turn of a gentleman. Every page marked, every element in his mind said, all right, issue notice, interim relief in terms of para 8C. Right? I explained the process in the beginning. The other side came up, filed a reply, filed a written statement, trying to convince the court that the interim relief is wrongly granted. His Lordship said that, all right, we'll admit this petition, we'll post it for final hearing, and we'll hear it at leisure, whatever your objection is. But in that meantime, status quo as on date be maintained. Status quo is maintained. 7 years down the line, the matter comes up for final hearing. The senior counsel who had then argued forces for an urgent hearing that, sir, this is how, we had been granted a stay order, and this is how this matter is urgent, and it may be listed on top of the list. His Lordships, while listening to that civil application, said, come back to that point which you had argued while obtaining interim relief. The senior counsel argued that point again. And the court said, what a hopeless point, and dismissed the matter. Right? So we cannot decide, we as lawyers or as the judge cannot guarantee a result. With that being said, our clients will not agree with this. They are and rightly so, they are here for a result. They come to the court after having all doors closed. They come to the court with the feeling that we'll get a result. They come to the court when they feel that injustice has happened. They come to the court when they feel that now things are out of my hand. At that point of time, a helpless litigant walks to a lawyer just to understand that he cannot guarantee a result. With that being said, I'll take you first briefly and then elaborate the provisions of Arbitration and Conciliation Act, the mediation rules. Again, at the cost of repetition, conciliation and negotiation is something which the law has a very less role to play. It is more on the parties. It's an informal process, sometimes statutory, sometimes non-statutory. I'll just read a few lines which from the famous book I have quoted. I quote, just like the diversity in the cases or causes of dispute, the settlement models are also varied. Alternative dispute resolution encompasses a wide area of practices which are directed towards a cost-effective and quick resolution of disputes. ADR, as the name suggests, is an alternative to the traditional process of dispute resolution through courts. A query which I normally get from the interns who attend my office, that sir, arbitration, is it just like a court process? Sir, arbitration, is it legal? Sir, how do we frame judgment, or how do we get the judgment from arbitration? Today, in this small brief session, I'll try and cover up all those issues one by one. Now, let me take you first to what is arbitration. Arbitration and Conciliation Act initially was brought into practice by our predecessors, the British, in the year 1940. Normally, this was at that time a border resolving dispute system. When the unfortunate partition of our nation was going on, there was need of a law which gives you finality, which gives you no appeal provision, that this is the award, this is the finality. Many places which we in the popular culture do not know of are resolved through the Arbitration Act awards of 1940. And that's how many state boundaries and many borders have been incorporated. In the year 1996, there was a need to amend this law so that it can be put more into usual practice, so that it can be put more into practices where finality is required. Now, a very pertinent question or a very pointed question, which disputes can go to arbitration? The list of which cannot is longer than the one which can, right? Wherever quantum of damages can be measured in terms of money is the direct answer for arbitration. In simple words, a commercial dispute is a fit case to be arbitrated as per the Arbitration Act 1996 and the amendments thereof. First, I may read for you the provisions of Section 8, whereby parties are given the choice and authority to decide as to whether they want to opt for arbitration or not. If our friends here, any of them are taking notes, I may repeat Section 8. I may read the power to refer parties to arbitration where there is an arbitration agreement. Imagine a situation, hypothetically, that there are two parties. One party is the owner of the property and the other party is going to construct, say, a building over that plot or that parcel of land. Now, this being a contract which may involve number of nuances, by how many windows the building may have, how many staircases the building may have, how many elevators, the fire exit, the front door, the rear door, parking area, margin line, all these discussions, kitchen on the front, restaurant at the top, we don't know, right? So if, for example, while constructing this building, there is a dispute. There is a dispute and there is no provision called an arbitration agreement. An arbitration agreement can be in two forms. One in the form of a clause inside the contract itself, or a special agreement made for that purpose. And by a latest Supreme Court judgment, also by the communication between the parties. right? So with that being said, in the absence of an arbitration clause, the party has only one recourse: to file a civil miscellaneous application before the district court in the relevant provision where the dispute lies. Nature of the dispute may be civil, may be criminal. The jurisdiction of the court may be of special nature. For example, if there is any environmental law which is being violated by the person who is constructing it, then the civil court may have no role to play. It is the Green Tribunal which will have the role to play. So all these things can be directly referred by the parties by way of either an arbitration agreement separate from the main contract, or by way of a clause within the contract, in which, in simple words, it can be said. Now, since I am grateful to my father's office that I draft many of the contracts, so the simple line of an arbitration clause or an arbitration clause in a contract would be: all the disputes to be hereinafter to be referred to Shri so and so, who may be appointed as the arbitrator jointly by the parties. In simple words, this will be the clause. Now, this is as widely worded as possible: all the disputes. So whether there is a dispute or not, that itself is a dispute. For example, if a party issues notice that these are the violations that you have done, the other party denies it, that no, these are all part of the contract which we had already agreed upon. So that in itself is a dispute. कि आ बधी तकरारो શરૂઆતમાં છે કે નહીં? Kartikeji, I hope you don't mind. I may use some of the Gujarati things to explain the situation, because I am reminded of something whenever I hear the word dispute, or whenever I hear the word takrar. In the recent time, I am reminded of something which I heard recently by a very famous Gujarati writer. He said, "Ke sahab, aje manas agro thai gyo che. Today, human race as a race is difficult to deal with." I asked him how. He said, "Sir, મેં છે ને એક મકાન ભાડે લીધું. તો જ્યારે મેં મકાન છોડ્યું ને, ત્યારે મારો ઘરધણી બહુ દુઃખી થતો હતો, બહુ રડતો હતો. તો પેલો નવો ઘરધણી, the new landlord said, હું નહીં રડું, કારણ કે હું ભાડું એડવાન્સ લઉં છું." So, in order to make this session a little bit interesting, I hope the audiences are pretty comfortable with this, because this is a technique which we as professors normally use for our audiences to get the lectures interesting. Because otherwise, if I blabber about the provisions of the law and I don't give any practical examples of a life-turning situation, the audiences at the end of the day will get bored. And like I said in the beginning, I would want any of my brothers not to get bored with this little soul here. With that being said, I may read further. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party so applies, not later than when submitting his first statement on the substance of the dispute, refer the parties to arbitration. Now, if I take you to the judgments which have been recently pronounced by His Lordship's Justice Ramanna, the Chief Justice of India, as well as Justice Nariman, consistently the Honorable Supreme Court and the High Courts throughout the nation are of this consensus view that once, if the contract is having an arbitration agreement, which means to say a dispute resolution mechanism provided in the contract, the role of the court ends there. It is the moral duty of the court to relegate it to arbitration. Now, we have lots of friends here, I believe, practicing in the civil courts, and we have this beautiful piece of legislature, the Civil Procedure Code. I may take one of the provisions from here too, and that is Section 89. Section 89 again clearly says that when the court is of the opinion that this is a fit case where settlement of dispute outside the court is possible, looking to the possibility of that dispute, it may be referred to arbitration. I may read settlement of dispute out Section 89 Civil Procedure Code, settlement of disputes outside the court. Where it appears to the court that there exist elements of settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observations, and after receiving the observations of the parties, the court may reformulate the terms of a possible settlement and refer the same for A, arbitration, B, conciliation, C, judicial settlement including settlement through lok adalat, D, mediation. I shall try and cover up all of these today in our session, but let us begin with this simple formulation which section 89 says, where it appears to the court. Now, I believe all of us at some point of time have seen life very closely going by and not realizing how fast it is, not realizing how time is passing by. But the Honorable Judge, you and me may have personal opinions of whether the chair or the person is the noble person sitting there or not. That may be your and my personal opinion. But in reality, the person sitting there is seated there because there is some reason. He has seen life a little bit more than us. Let us give this credit to that person sitting on that chair. Maybe a district judge, maybe a civil judge, maybe a high court judge, maybe Supreme Court judge, but today he's the judge. We have to give him that credit. I am reminded of an instance from 2013 where I was briefing my father and I told him that, sir, we have these 12 beautiful points, 24 Supreme Court judgments. Let us just crush the other side. He said, hold on, young man, hold on. Your whole intention or your whole preparation is going on only one direction, that you want a favorable order or a judgment, right? What about the person who's actually going to say this is right or wrong? Your job is over the minute you argue, but ye to bichara laine baitha hai. He'll have to say right or wrong. Give him some credit, give her that credit, give him that credit. With that credit being given, Section 89 CPC says, see, where it appears to the court. Now, this discretion is left over to the court. It may so happen in litigation, it may so happen in disputes that the parties or the advocates, now I'm not discrediting the brothers at bar, our brothers at bar are very responsible, they put in all their efforts, but it may sometimes so happen like every coin has two sides. So we may come across some side which wants to make sure that the matter does not reach finality. We have on that other side also. Recently, there have been quite a lot of examples for both sides, but larger issues some other day, not today. But I am reminded of an instance which is a personal experience. And since the matter has now been disposed of, I can discuss this. It's not an ongoing case in that sense. It was a matrimonial matter where Section 125 application, that is for maintenance, was filed by the wife before the family court. And the family court very reasonably granted 20,000 per month as interim maintenance and finality to be considered later on. With that being said, the husband came up to my office and said that, sir, I wish to challenge this. I said, you should certainly do so, but I may remind you that there is an FIR also pending on you with the charges of 323 498A. What about that? Should you approach the High Court with a quashing petition challenging this order as well as the charges? Do you want to give this a try? He said, Sahib, je madad made sachi. I said, okay, no problem, but understand it for a fact that I will make this request for you only and only if you feel that you should settle the matter, not otherwise. Because ultimately you are both what, 23, 24 years of age, 26 years of age. You have beautiful life ahead of you. Why do you waste it? With this preparation that in fact all the merits may be in your favor, but still you will settle, I take up the brief. I said, all right. Matter came up before hearing when Madam Justice Sonia Sukhwani, sitting as a learned single judge, was taking up quashing and criminal matters. I took her ladyship to the cause title of my petition, showed her the age of the petitioner and the respondent, and her ladyship said that they are pretty young. Don't you think, Mr. Sukhwani, this will be beneficial that if both of them settle? I said, certainly it will be. Should you be granted an interim order and the reference to mediation for further settlement? Now, I'm not taking up mediation right now. I'm just sharing this instance just to show my old brothers that how parties sometimes not realize what will be the consequence. With that being said, matter came up before the mediation center. I told the lady who was appearing on the other side, the lady advocate as well as the lady client, the wife, I folded my hands and said, sister, you can see a brother in me. Tell me your demands. If at all you wish to settle it, tell me your demands. I can harp upon my client that at least 70-75% of it he can be in the capacity to fulfill. We can take this further. And your life will be saved from tiresome litigation. She prima facie agreed and said, all right, by the next occasion, I'll come with the demands. Said, very nice. On the next occasion, they came up with a list, a 4 BHK flat in Surat, a Maruti car, 20 lakh rupees in cash, and the investment which the husband and wife have jointly made in a bank account, her share of 50%. I asked my client that, see, the demands are on the higher side, which is apparent, right? But today she is favored by an order of 20,000 per month, which you otherwise have to pay. And if this, even if there is a stay order protecting you from the police action, you are not free from paying that amount. You have to pay. અને જેટલા એરિયર્સ છે એટલે ઉપર આવશે કન્ટેમ્પ્ટ કરવાનો ચાન્સ એટલો વધારે. With that being said, he said, sir, મને 2 અઠવાડિયા આપો. I will come back to you with whatever legitimate I can provide. I said, all right, do so. He took his time, came back with a booking form where he had in Ahmedabad to a local Maruti dealer, he had filled in a booking of 10,000 for a Maruti Alto. He came up with a builder's booking form of a 2 BHK flat, not 4 BHK, but 2 BHK flat, and photographs of the actual flat. એવું નહીં કે ભાઈ અત્યારે બુકિંગ કરી પછી possession મળશે અને પછી આ ready flat, ready possession flat. And he showed his bank balance that 5,75,000 he has in the bank. He'll forget the 5 lakhs, give it to the wife and live happily ever after. Pure sarcasm, not that the people are married who are not happy, એવું નથી. જે લોકો પરણેલા છે સુખી નથી એવું નથી. But this was his ideology. I said, all right, put this all in affidavit and give it to me. He said, sir, I'm ready. Kal sudhi. In the mediation center, I proposed this to the mediator that, sir, this is how our offer is. She has asked for a little bit more than this, but not that little bit more. We can provide this much. The honorable mediator put, sir, this affidavit that jo ben hai to affidavit par lai aaya છે એટલે આ બધી વસ્તુઓ સાચી અમને prima facie તો માની લેવી પડે. And he asked her that, what is your reply? 2 words. It took her 2 seconds and 2 words to say, Nathi joitu, na padi do, no. All right, no difficulty. Matter is remitted back to Madam Justice Gokani in the court. May the 5th is the date, afternoon 1:45. When the court tells me, when I make a mention that this is how the mediation has failed and this is how this will now have to be argued. Madam said, are the clients present in the courtroom today? I said, yes. Will they accompany me to my chamber so that I can put some counsel to them? I said, certainly, we would love to. The clients of both sides, both the advocates were called upon. Her ladyship's tried best of her wisdom to be put to the girl that this money 5 lakhs, you put it into an FDR, you yourself are working, you will have a house, you will have a car, a new life to start with. And the only reply she gave, Nathi joitu. Nahi. He either gives me whatever I ask or nothing. Said, very fine. All right. Matter came up for hearing, and very strategically, the other side gave me an application for vacating interim relief. I said, May the 8th, the High Court goes on vacation. May the 5th, 2:45, you give me this application. I am bound to ask time for a reply. So should I understand કે જે સવારમાં તમે mediation માં આવ્યા ક્યારે સેટલ કરવાની કોઈ દાનત હતી જ નહીં? He said, ના ના આ તો હમણાં 15 મિનિટમાં ડ્રાફ્ટ કરી. Believed, brother at bar, believed. Matter came up to the court. The copy was given to the court. Her ladyships looked at the copy and told me, you will need time to file reply. I said, certainly I will. Is your offer still open? I said, certainly it is. Counsel, do you accept the offer? No response. No. Whatever we asked or nothing. All right, fix up final hearing in September, interim relief to continue. So simple. So simple. Because the party who cannot understand their own benefit, nobody can help them. Now, I am given this query so many times that, sir, despite the fact that we have such beautiful alternate dispute resolution, there is pendency in lakhs. Surprisingly, subject to correction from all of my brothers here, in the US, the pendency is 40,000 cases. That's all. In the all of US. Because 90% of the cases don't go to court. 90% of the cases are settled this way or the other. Now, we are not saying that settlement is the way out or it should be done. There may be cases where there cannot be no middle ground. There just cannot be no middle ground. And I believe I would not want to spell out what those cases are, but there may be facts and circumstances in which no middle ground is possible. There, we don't encourage a settlement, but at the same time, if thought a little wisely, there is a fairly good chance that all these alternative dispute resolutions will come to life if the attitude of the parties is a little bit more cooperative. Now, I may sound as if I am blaming everything on the parties. I may sound like that, understood. But it is rather the statute which is so transparent, which has given parties the free choice, as we just saw in Section 8. We just saw in Section 8 that it is the parties who have to decide. Now, having this thing in mind, let me take you to Section 11, subsection 6, and Section 12, subsection 1, subclause B of the Arbitration and Conciliation Act 1996. Now, these are provisions for appointment of arbitrator, who can be appointed as arbitrator, and who will appoint the arbitrator. For example, in a given case, if the parties already have an arbitration agreement, and if one party has a dispute, say, I will use this building and the plot example as it is fresh in your mind. In that building example, the employer, that is the landlord, says to the contractor that, sir, I want a glass wall here, I want a chimney on the left hand side, I want a kitchen in the front end, a living hall in the center, a home theater in the first floor, and the rest of the rooms of this building shall be later converted to a hotel. Now, all these specifications, the learned employer had not incorporated in the tender. The tender was only for constructing a building, which should have 12 stories, and the plot area for gardening. Now, in this situation, can the contractor say that I wish to abandon the work? That is again a harsh step on his side. But the minute the contractor will say this, that I wish to abandon the work, the employer will have no option but to issue a notice as per the clause. Read with Section 11 of the Arbitration and Conciliation Act 1996. I may read. If the appointment procedure in subsection 3 applies, and if a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, or B, the two appointed arbitrators fail to agree on the third arbitrator within 30 days from the date of their appointment, the appointment shall be made upon a request of a party by the Chief Justice or any person or institution designated by him. Now, this example I will elaborate a little bit more, that the clauses, there are many clauses in which the arbitrator is named, that Shri so and so to be the arbitrator, or the person designated as the chair. For example, if it is a private limited company, the managing director of the so and so company shall be the arbitrator. Now, if there is a dispute, within 30 days of notice or a request, the other party has to be intimated about this clause, that this is how, gentlemen, we have the authority, this is how we seek to appoint, and this is how the dispute resolution shall proceed forward. Now, we read here by the Chief Justice or any person designated by him, which means that the Honorable High Court will designate a court which will specially take up Section 11 applications, which means to say that the job of this court or the Section 11 court will not be to sit and find out who is at fault, but it shall be to figure out who can be appointed as an arbitrator. That's all. the Honorable High Court, in the exercise of Section 11, is not functioning as a court of record, nor is it functioning as a court of rights, but it is only functioning as an administrative designated post as per the section for the appointment of the arbitrator. Now, with that being said, I have one more example to share before I take you to the fifth schedule, that is section 12, subsection 1, subsection B. This is from year 2017. 2017, the month of February. I have a very dear friend, Mr. Sheikh, who normally operates from the Honorable Civil Court. Morning 10:30, I get a call from Mr. Sheikh asking me if I am available for a short conference. I said, all right, you can come in. I see a 78-year-old man who is looking like a farmer. I'm not being linguistic or regionalistic here by saying looking like a farmer, but the attire was such that he works in a farm, looks like. And the minute he sat, he said that, yes, sir, I am a farmer. Who cared with you? I said, all right, what brings you here? Because this is an office specializing in arbitration and contract matters. How come a farmer lands up into an arbitration dispute? And he said that, sir, I had purchased a tractor on hypothecation from a finance company. Now, finance company has this scheme of yearly installments that per year he has to pay 98,000 and odd, which we'll consider this amount for the sake of brevity and understanding the case as 1 lakh. For example, 1 lakh per year and 5 yearly installments, 5 lakhs of his total, which is due to the company. And the cost of the tractor is 7,50,000. So 3 installments he could pay, 2 he could not pay. The finance company takes possession of the tractor, sells it for an amount of 6,10,000. So by now 6,10,000 for consideration of the tractor and the 3 yearly installments. 9,10,000 the company already has. And then this gentleman and Mr. Sheikh show me an arbitration award, which is by the CEO of that very finance company. And I go through the record and I figure out that the notice which is given by the arbitrator nominating himself and appointing himself as an arbitrator and the date of award, the total time in this is a record-breaking 24 days. 24 days, record-breaking, unheard of. Because as we just saw, 30 days is the period which is prescribed by Section 11 for the notice. I asked him that, Kaka, ऑफिस में जवानी के साहेब पासे जवानी तक तमने मळ्यो तो कोई समन्स कोई नोटिस. And the old man, to all his sympathy and empathy, replied that, sir, અમે જ્યાં પેલા સાહેબે કીધું આમ અંગૂઠો મારો તો ત્યાં અંગૂઠો મારીને લોન લીધું હતું, એ પછીને અમને કાંઈ ખબર નથી. Said, all right. In a record-breaking 24 days, there is an award by the honorable arbitrator, who is the CEO of the company. Now, first, before my brothers here and sisters here get confused, the judgment delivered by the arbitrator will be the award. Section 2 takes care of all the definitions and the words which the nomenclature uses. So arbitration award will be the decision of the arbitrator. And this award was passed for a staggering amount of 10,25,000 and odd, with cost of litigation and interest to be calculated at 12%, unheard of in this time of the year or in 2017. With that being said, I saw a judgment of Section 34 as well. I will take you to Section 34, but the point which I am trying to demonstrate before this August gathering is Section 12(1)(b), who can be appointed as an arbitrator. The first appeal, of course, was supposed to be filed before the Honorable High Court in that case. And Her Ladyship's Madam Justice Bela Trivedi, as she then was, I pressed into service Section 12(1)(b), asking to myself before the High Court that how could this man have been appointed as an arbitrator? It's a fair, equal dispute resolution process which is being made a mockery of. Now, merely because the clause of the agreement says that in the event of dispute between the parties, that is the debtor and the creditor in that loan agreement, the CEO of the company shall be the arbitrator. Merely because this clause gives the employee of the company the authority to act as an arbitrator, can a human legal mind like yours and mine believe that justice will prevail? A difficult proposition to argue to oneself, to convince oneself that yes, it may prevail. With that being said, I pressed into service this section which takes down or which jots down the relationships where these relationships give rise to reasonable doubt as to the independence, integrity, and impartiality of the honorable arbitrator. I may read the following grounds give rise to justifiable doubts as to the independence or impartiality of the arbitrators. Arbitrators' relationship with the parties or counsel. Number one, the arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with a party. Two, the arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. Three, the arbitrator currently represents the lawyer or law firm acting as counsel for one of the parties. The arbitrator is a lawyer in the same law firm which is representing one of the parties. The arbitrator is a manager, director, or part of the management or has similar controlling influence in an affiliate of one of the parties if the affiliate is directly involved in the matters and dispute in the arbitration. The arbitrator's law firm had a previous but terminated involvement in the case without the arbitrator being involved himself or herself. The arbitrator's law firm currently has a significant commercial relationship with one or of the other parties or an affiliate of the other parties. And now this is very important. A close family member of the arbitrator has significant financial interest in one of the parties or an affiliate of one of the parties, and many more such, which give justifiable doubt to the independence or impartiality of the parties. In as much as the law presumes or the law assumes that if these circumstances prevail between the person and the other side, will give justifiable doubt to the independence and impartiality of that arbitrator. Therefore, when in section 11, the High Court is considering appointment of an arbitrator, the former judges of the Honorable High Courts or Honorable Supreme Court, in my say, should be given a priority. In as much as the person who has already been the epitome and symbol of justice qualifies all of these which are jotted down in section 12, subsection 1, subclause B. With that being said, let us come to the very important aspect of why this provisions or this process over the regular court process. Answer lies in section 29, subsection A, subclause 1 and subclause 3, that is time limit to complete the proceedings. Now here, very interestingly, these amendments are no doubt part of the recent amendments, but the learned arbitrator is required to complete these proceedings within 12 months from the date on which he enters reference. Now, what would be the date on which the Honorable Arbitrator enters reference? It shall be the date on which the pleadings stand complete. When we say pleadings stand complete, which means as per our Code of Civil Procedure and as per the usual court practice, as we all know, that is our plaint, the written statement, rejoinder, sur rejoinder, if any. Now, when all these stand complete, that's when the limit for the 12 months will begin. Now, there are two interpretations to this. One is a positive one and one is a negative one. The positive one says that date of reference shall be after the completing of the pleadings. The negative is that 12 months is the total timeline. Either which way you consider, but as a litigant, as a lawyer, or as a judge, this is a provision which is bound to help you in as much as there is a timeline to be ethered. In as much as if this timeline is not ethered, then what? Then as per this very application of section 29 subclause A, you will have to file an application for extension of time limit before the very section 11 court who had granted you the appointment. Now, in our experience, this process is, in my respectful say, very embarrassing for any lawyer to say that, sir, we have not been able to complete the proceedings. Various reasons, sometimes justified, sometimes not justified. But in this situation, in all propriety, the court may say that, sir, we are not inclined to give you this extension for the next 6 months, as we see from the record that this party or that party has wasted a lot of time. So we may put you to some conditions and cost, and then we can grant you an extension. With that being said, this, as per my say, gives some satisfaction to the parties that at least a dispute is seeing some daylight. There is some development. It is not as if there is a stale claim being adjudicated from time to time, like unfortunately it happens sometimes in some old cases. But this, in my say, is very result oriented. Now, coming to the part of remuneration and cost of the arbitrator or arbitration proceedings. As we all know that there is a concept called court fees. All our brothers have been to this very age-old concept where your price or your cost of litigation is the cost of your dispute, in as much as you have to pay some fees, which as per the Civil Courts Act, there is a table, and in what table your claim falls in, that's the amount of your court fees. Unlike here, in the Arbitration Act, now as amended, there is a schedule. There is a fixed schedule to which nobody can say that my fees or my remuneration may be something different than this. Of course, there are people who have their own ideology, but in our recent experience, there have been judicial orders to the effect that this shall be the maximum ceiling limit of the fees which the learned arbitrator may charge. In the legal scenario, so far as the statute is concerned, the answer will lie in the 7th schedule. In the Arbitration Act as amended in 2015, the answer is 7th schedule. There will be on the left hand side the sum in dispute and the model fees. So if the dispute is up to rupees 5 lakhs, the model fees shall be 45,000. Now, I have heard this in the past, and I keep hearing this from many of our brother lawyers, that a particular person who was appointed as arbitrator charges per hour or some charge per day. That may be their practice, and they are also very clear in their thought process that if the dispute requires our adjudication, then pay this and we'll adjudicate. Sometimes this approach is deprecated so far as our state is concerned, but many large industrial firms in Mumbai or say in Delhi or abroad in the international commercial scenario are sometimes willing to pay these remunerations and get their disputes adjudicated if their agreement permits. Now, with that being said, does it make this a little defeating so far as cost effectiveness is concerned? Now, if my suggestion were to value, then yes, everyone may not be able to afford a judge in that sense. With that being said, let us put you through now the award and the process which is undertaken in so far as arbitration is concerned. Section 19, subsection 1 makes it very clear that the Evidence Act and the Civil Procedure Code are not supposed to be followed strictly, which means to say if the parties want to avoid or if the parties are not willing to give oral testimonies, that is something which the call can be taken by the parties and the arbitrator that we wish to not have oral testimonies or witnesses. So far as section 19 is concerned, it is supported by recent two decisions, one by the Honorable Delhi High Court, one by the Honorable Supreme Court, which says that if a party does not want to go through the process of testimony, it can do so. In as much as the arbitrator is given the discretion as to overrule the requirement of a witness. Now coming back to the part of arbitral award and judgment. Now, since all of these clauses, in so far as arbitration is concerned, they are binding. The clauses themselves say that the result of these proceedings shall be binding upon the parties. Let us now understand that how binding and how this binding nature turns into finality. First Appeal 1379 of 1992, a beautiful judgment by our Honorable Gujarat High Court, which has laid down guidelines for the court below as to how to deal with arbitral awards. Now, before we go to that, let me read for you the recourse to an arbitral award as per section 34. Now, section 34 is the way out if in, now see, law is sound, common and robust in as much as it will not leave any room vague. There are queries like this, that what in the event if we are not satisfied with the arbitral award? The answer is section 34, which provides you the recourse to challenge an arbitral award. It is titled as Application for Setting Aside Arbitral Award. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. Subsection 2, an arbitral award may be set aside by the court only if A, the party making the application furnishes proof that 1, a party was under some incapacity, or 2, the arbitration agreement is not valid under the law to which the parties have subjected it, or failing an indication thereon under the law for the time being in force. 3, the party making the application was not given proper notice of the appointment of arbitrator or the arbitral proceedings, or was otherwise unable to present his case, or the arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to the arbitration, or it contains decisions on matters beyond the scope of the submission to arbitration. 5, the composition of arbitration tribunal or the arbitral procedure was not in accordance with the agreement of the parties unless such agreement was in conflict with the provisions of this part, from which the parties cannot derogate, or failing such agreement was not in accordance with this part. Now B, the court finds that the subject matter of dispute is not capable of settlement by arbitration under the law for the time being in force. 2, the arbitral award is in conflict with the public policy of India. Now, with this being said, these grounds or this section 34, courts, in as much as the Honorable Supreme Court, as well as our Honorable High Court, as well as the Honorable Bombay High Court, Delhi High Court, all these high courts are consistent so far as public policy is concerned. What would be known as public policy? Because as we just saw, rest all the other grounds are somewhat apparent. Like, for example, if the party has not been given a proper notice or is not being given a proper hearing, that will be something which is apparent on the face of it, right? That will be something which the record will speak for. What about those arenas where discretion or gloominess may be the reason for a wrong decision or a deliberately wrong decision? That in the judgment of Sangyong Industries and the National Highway Authority by Justice R.F. Nariman has made it very clear that if the decision or the conclusion arrived at is so erroneous that it shakes the conscience of the court that no reasonable person could have arrived at such a decision, is or can be called the violation of public policy of India. Now, will this public policy of India include the statute? Answer is yes. Will this public policy of India include the judgments which may have been laid down by the court? Answer is yes. Will this public policy of India include discretion exercised in as much as could not have been exercised? Answer is yes. With that being said, the room for interference so far as section 34 is concerned is very limited. Now, just minutes ago, I mentioned a beautiful piece of judgment by our Honorable Gujarat High Court, which goes to an extent of providing guidelines for the Honorable Civil Courts. Now, just to clarify my stand, so far as Gujarat is concerned, Section 34 applications are to be entertained by the Honorable Commercial Court, or known as in the common language as Honorable Civil Court, because as per the Arbitration Act, Section 2, subsection E, the definition of courts would include the Honorable Civil Court or the Commercial Court or the District Court, and not the High Court. The High Court is of course included, but so far as for the purposes of Section 34 is concerned, the definition of court includes the Civil Court. While so far as Bombay, Delhi and Madras is concerned, the Honorable High Court in their rules have already amended the rule so far as ordinary original civil jurisdiction, so far as arbitration matters are concerned, will be exercised by the High Court. So not to be confused that when we say challenge before the court, in Bombay, it will mean challenge before the High Court. Section 34 application is directly taken up by the Honorable Single Judge of the Bombay High Court. While so far as Gujarat is concerned, it will go to the Honorable District Court, Civil Court or the Commercial Court as the case may be. Now with that being said, Section 37 provisions are for appeal before the High Court, that once this Section 34 examination has been done, the room in Section 37 is even more narrow, and that will be read with Section 36 subsection 3, that is award would be money decree, in as much as, like I said in the beginning, that all these commercial disputes where damages or sum can be measured in terms of money, the party is bound to be compensated after the award. So this way or that way, the result will be visible. With that being said, for my brothers, for all the lawyer brothers here, though I believe all of them have some at one point of time or the other have gone through this, but just a small saying which I had learned many years ago, and that is, a lawyer should never instigate to litigate. The job of a lawyer is to unite the parties. Now, when I say this, I am reminded of the beautiful provisions of mediation. So far as arbitration is concerned, most of the act I have tried to address and cover. Most of it is already covered. A few provisions or a few landmark cases which I would want to highlight so far as myself is concerned and my relationship with arbitration is concerned. I am reminded of this beautiful matter which ultimately was settled. Now, all of the listeners or all of my brothers and sisters here must be thinking that a settlement in an arbitration, yes, that also happens. My client had an enormous claim of, say, I don't exactly remember the figure, but in crores of rupees, the construction he had undertook of 2-3 projects, all of them governed by a single contract having an arbitration clause. And ultimately, the contract had clauses where supply of material was on the employer. And admittedly, the register, the cement register, the material register, no entries, no supply was made. 6 months, my client made communications after communications that supply me this, supply me that, so that I may undertake the construction. His Lordship's Justice Harshvardhan B. Antani appointed as the arbitrator by His Lordship's Justice Qureshi, as he then was. And the matter proceeded. I urged on the first meeting with my claim statement that, sir, this is our loss of profit, this is our loss because of the breach on their part, and the damages which I could have earned by executing this contract. The claim was a good number of crore of rupees, and His Lordship's Justice Antani said that I have just gone through your claim statement very quickly, and it prima facie appears that there is no supply of materials from the employer. Am I understanding the case correct? I said, Lordship, please. And he said, but don't you think that you are pushing your case too much when you ask loss of profit in as much as what you could have earned if the agreement was complete? I said, sir, I am covered by 3 judgments of the Supreme Court so far as that claim is concerned. And he told me that in all humanity, can you not ask your client to charge some amount and begin the work again? And this time with an undertaking that they will supply you the materials on time. I said, sir, we have burnt our hands so far as this contract is concerned. I'm not very hopeful, but let me put a word. My client very happily said that, sir, if they pay us our mobilization advance and the salaries which for the 6 months we have paid to the staff, if for this project, if these two aspects can be considered, we'll be more than happy. I said, all right. On the next meeting, I put up this proposal that, sir, he says that if the mobilization advance and the salaries of the staff, which for this project were paid for a tenure of 6 months, they'll be happy. Now, I'm thankful to the respondent back then. He said that, yes, we agree and we'll pay you this amount. And ultimately, a consensus award was passed. A consensus award that this amount the respondent undertakes to pay to the claimant within the period of 3 months. And if not paid within the period of 3 months, 7% interest we awarded to the claimant. And the matter was ultimately settled. We went to execution, executing court affirmed the settlement, the amount was also paid. Now, this also happens. But with that being said, it is not always the conduct of the parties or the merits of your matter which will help you forth the alternative dispute resolution process. It is sometimes a little bit more than that. And that is the situation. In what situation you approach or in what situation you are exactly in. Because it is rather said that every aspect or every narration, every circumstance has 3 sides. One, your side, one, the other side, and one, the truth. So all of the parties, especially in litigation, especially in brute commercial litigation, where quantum can be measured in terms of money, know the third aspect very well. Know the third aspect very well. And that is why sometimes it is very easy to let the parties decide their best. With that being said, I now move on to mediation. I believe we are Kartikeji.
Yes, sir.
I believe we are good so far as timing is concerned. I might overshoot by 5-7 minutes. Would that be okay?
Yes, definitely.
Yeah,
That's
not
fine.
any issue, sir.
Thank you. With that being said, let us move on to mediation and another beautiful aspect of something which we call alternative dispute resolution. Now, this small write-up, if brothers and sisters here, any of them, if are writing notes, I may read out very slowly the 10 reasons to keep it out of court, or rather the 10 commandments of mediation. Number 1, focus is on resolution, not battle. Number 2, creates win-win situation for all the parties. Number 3, avoids unpredictable outcomes. Number 4, costs far less than litigation. Number 5, goes at your own pace. Number 6, improves communication. Number 7, preserves relationships. Number 8, maintains your privacy and is confidential. Number 9, narrate your story and be heard. And the last one, no stress, no juries, no judges. Now, mediation and arbitration are often confused for one or the other. I may just clarify by saying one thing, that mediation is an absolutely different aspect from litigation. In arbitration, of course, you are there to win also. You are there to make sure you have the judgment also. In arbitration, you are there, of course, to show your evidences, to show your part, to narrate your part and get justice, which means dispute adjudication in arbitration is very much present, which means your evidence, your narration, your claims, your disputes will not only be entertained, but will also be adjudicated upon, which means the old saying of a trial, that the trial is not there only to see whether the accused is guilty or not, but the trial is also there to see whether the complainant is truthful or not, right? With that being said, mediation is an absolutely different arena, a bigger wing of an alternative dispute resolution aspect. In as much as number one, focus is on the resolution, not battle. When we say this, mediation focuses only on one aspect, that what is the solution? What is the problem and what is the solution? There, in mediation, I must say very nicely that there is no right or wrong. Sacha kota nahi hota, right? There is no right or wrong in mediation. In mediation, there is only solution. And just like when we say arbitration is beautifully fit for commercial matters, I must say mediation is beautifully fit where judgment is not possible. Now, this takes me to a very emotional aspect of life, and I apologize if I get a little emotional or a little drowned upon when I address this, because a subject which is very near to my heart, a subject which I love to narrate on, and a subject which has been part of everyone of our life, right from the era of Mahabharata. When Shri Vasudev Kishan, when had traveled to Hastinapur as a mediator, as a Shanti Doot, he was just there, knowing fully well that it may not be successful, but just for the sake of peace and happiness of all, he did attend that. उन्हें ऐसे अंतर्यामी नहीं कहते, right? He knew that the other side is not going to give him anything, but he still made his effort. He still made his effort, knowing fully well of the fact that merits and the truthfulness, the dharma, the righteousness was in his corner. Still, he made his effort that if by my ego reduction or if by my suppressing my ego, if I get happiness and peace for everybody and if I avoid the bloodshed, nothing like that. With that being said, focus is only on resolution and the result, not on the battle. So whenever in mediation, if the parties are called upon, our instruction to the parties are only this much, that your focus is only to get the result and nothing else. And like just coming back to the aspect of how mediation and which matters, we just understood that arbitration fit for commercial matters where damages can be measured in terms of money or a right, title or interest can be tangible, looked at. Now, what about those matters where this decision or this exact adjudication is not possible? Now, very candidly, if I may say, no book, no lawyer, no judge, no court can explain a father and son or a husband and wife to live peacefully, or two brothers to live peacefully, or a family to live peacefully. No book can teach you this. No judgment can direct you this. No lawyer can plead this. It is something which the human mind, the human heart is built for, is supposed to be born for. With that being said, there will be cases and matters where, rather unfortunately or fortunately, you will have no pleadings. My colleagues, my juniors sometimes are very surprised that in matrimonial matters, I normally try and not to carry file or try not to carry the pleadings when the matter is likely to be settled. And my junior will hurriedly tell me that, sir, on this paper, on this file, there is the evidence. There is this finding. There is finding of the court. I said that, look, today you are here to mediate. Today you are here to make sure that there is a solution. And if you want a solution, no allegations. The minute you put an allegation, that is the minute you blemish the solution. So if you want a solution, just focus on the solution. The second aspect of this is it creates a win-win agreement or a win-win situation for everybody. Now, this is a little subjective, depends on matter to matter. Like all the husbands here may think that, sir, wife jode win-win situation now hai je ke sachu, which I also being an husband would agree. Lighter side, absolutely. So with that being said, all these aspects of these type of matters where the law may not help you, it is all factual and dependent on the parties. It can create win-win situations. And in the beginning, the point number 3 avoids unpredictable outcomes. In the beginning itself, I had narrated about the litigation and the outcome of things. Sometimes, many a times, the outcome as men. Now I'll divert this and dilute this a little bit with professional ethics. there are going to be clients, there are going to be people who will come to you and say, that's a guarantee this will be the result. That's a guarantee. Please give us a guarantee that this can happen. Or please give us a guarantee that this will not happen. I, with folded hands, tell them that, gentlemen, I'm not selling ice cream, pav bhaji, or light pankha here, that you press the switch, you cook it, and the taste will be nice, or switch power એટલે ચાલુ થશે જ. એવી guarantee અમે નથી આપી શકતા. It cannot be given, especially when you are dealing with the aspect of litigation. With that being said, unpredictable outcome is a very widely worded process, is a very widely worded phrase, in as much as what is the outcome that we can predict in any aspect of litigation? That the petition or the plaint may be allowed in full, may be rejected in full, but the honorable court may want to find out a way for you, may refer it to mediation. How do we know? Human mind, human heart, the only science with no psychology, the only science having no definition, the only science having no precedent is the human heart and the human psychology. How do we guarantee that this human will react in this manner or this fashion only? Not possible. So the outcome of any litigation is bound to be unprecedented and is bound to be unpredictable. Mediation, per contra, saves you from that situation where the parties are in full control of what they wish to decide, what they want, what they don't want. But as we just had a glance on this aspect, that every matter, every aspect may not be something on which settlement is possible. Keeping that aside, benefit so far as mediation is concerned, today we are fortunate to have many courts. All of the courts mostly have a mediation center attached to them. And if the court finds, as we just saw in section 89 CPC, which is applicable to high court proceedings as well, where the court finds, now the honorable judge, as I just narrated an instance of my own where I appeared for the petitioner, the court was kind enough to see through that, the court was knowledgeable enough to see through that there is a fair good possibility of settlement. It did relegate it to the appropriate forum for settlement, but the party or the other side felt that the court can give better relief than what the settlement could have. All the best, but reality far different from imagination. With that being said, next point, go at your own pace. Now, see, again, mediation also has its own timeline. 90 days as prescribed by the rules, 60 days for high court, and the extension can be sought for by the honorable mediator if there is a fair good possibility of settlement. I am proud to tell all of my brothers and sisters here that I was part of a mediation which was appointed from the Honorable Supreme Court, and the parties had 12 cases lined up against each other. And when we say the parties had 12 cases lined up against each other, each and every listener here thinks or feels must be two private international companies or must be two private companies fighting for money endlessly. Untrue for your imagination, it was a husband and wife. Yes, a husband and wife matrimonial matter went up till the Supreme Court, where each party had filed not less than 10 cases against each other, alleging something or the other. Thankful for us, the bench of Justice M.B. Lokur, who was very result oriented and had a very mediation oriented mind, could see through that there is a fairly good possibility of settlement and there is nothing but ego battle going on. And he asked our counsel, Mr. P. Chidambaram, that Mr. Chidambaram, would your party agree for a settlement? I was the instructing counsel. I replied that yes, we are ready, but not here in the court premise. Said fine. Other side, Miss Indu Malhotra, as her ladyship's then were as a lawyer, and Shri N.J. Bhatt sir was appointed as the mediator. Saturday and Sunday, we used to devote this for this private mediation. Morning 11 on a Saturday, we would begin, and the session would go on for both days inclusive. About after spending 9 weekends like that, with heavy heart, we had to say that the result could not be obtained because of one party putting up allegations having no basis in the mediation proceedings, and ultimately the parties said that we don't wish to continue this mediation further. So the end result of this is that the matter goes back to file as it was. So if it was a section 125 application for maintenance pending before the Bombay court, it goes back there. If it was a police complaint pending at driving at Vastrapur police station, Ahmedabad, it comes back here. With that being said, when we say go at your own pace, it gives parties a lot of their own room. Now, this room sometimes transforms to excellent settlements. Sometimes it is an ego clash. But normally, like I said in the beginning, that manasave agro thai gyo, the human race is difficult to deal. And I believe all my brothers and sisters must be having such interactions daily, time and again, where they see that the human aspect is getting difficult to deal with day by day. This is all on the lighter side, of course. With that being said, we come to an aspect that what happens to parties when especially they are related, they know each other, and they come to litigation, or they face each other in a court case. What happens to those parties? Do they go back on talking terms? Do they have excellent relations? Do they maintain what we know as relations? Answer is an absolute no. The minute first allegation or a first averment comes from any of side of the council, and we are with heavy heart, we have to say the relationship goes on one side, the case goes on the other, and the people start living with this trauma inside them that that the situation will not change now. For example, not for example, I can again disclose this matter, no difficulty, it has been now disposed of. It's not an ongoing case in that sense, because I believe we cannot discuss an ongoing case. But since it is over, we have learned from this. And there was this family, and they had arbitration clause in their family arrangement so far as their HUF was concerned. Now, unfortunate for the family, the Karta passed away, and how to take it further, there was a dispute. So one party, the brothers on one side, the sisters on the other, and their husbands, of course, on the other. The brothers issued the notice saying that since the Karta in his will had mentioned that in the HUF, the sisters and their husbands shall have no right. Of course, the law on the subject also supports this aspect, but they issued this notice that the arbitrator be appointed. The Honorable Section 11 Court dealing with this subject said that, all right, we will appoint, but since this is a family matter, we would want the parties to explore some possibility of a feasible settlement. Now, like I said, today when the Honorable Judge is on that chair, there is some reason that he's there. You and me may have personal opinions and disopinions on people, but there is some reason that he's there. And within one meeting, the Honorable Judge came to the conclusion that where the shoe pinches. What I am told is that the parties never had a word after that arbitration or that arbitral award, coming to terms with their so-called relationship that this is how it is and this is how it shall be. This human race, as we know, has become difficult to deal, like we just had a word on. And it is rather unfortunate that with passing time, it shall get more and more difficult, not easy. Because we come to terms with it. We honestly come to terms with it. We honestly come to terms with not talking. We honestly come to terms with not resolving. We honestly come to terms with having a pumped up ego on everything we deal with. With that being said, what happens when all this is clubbed in a litigation? The answer is stress and strained relationships. Mediation is exactly where, or the mediator is exactly where your bridge for that relation is revived. Your bridge of saving yourself, now not for the sake of anybody else, but for yourself. Think about this, that how much stress it involves in thinking that all this we have to take with us, right? So mediation being this such a pious process takes you or gives you this opportunity where you have the full right or full opportunity to improve communication amongst the parties, to improve their relationships, to improve and preserve what is the left of it. Because by the beginning of the litigation, now again, clarifying my stance, I'm not discouraging or I am not criticizing what litigation is. Litigation, of course, has its own side. Of course, finding justice, letting the truth prevail has its own side. But I am reminded by a very famous quote of a very famous writer, Shri Mirza Ghalib, and I quote, कुछ इस तरह मैंने जिंदगी को आसान कर दिया, कुछ इस तरह मैंने जिंदगी को आसान कर दिया, किसी से माफी मांग ली और किसी को माफ कर दिया. With that being said, this is exactly what mediation is. This is exactly where it takes you. This is exactly what the opportunity it gives of forgiving and forgetting. His Lordship's Justice R.S. Garg had once said in one of his lectures, which I distinctly remember, so far as mediation is concerned, that if I am wrong, I am sorry. If you are wrong, let's forget it. So that is the exact approach what a party must keep in mind when entering the arena of mediation, and that is exactly where mediation has its own pious process of giving the party that opportunity. Moving on, confidentiality or maintaining the privacy. Now, as we all know, in the good old days, as our senior call it, so in the court process, there is the cause list, there is audience. Today, there is YouTube live streaming also. The world can watch. The world can watch. If a family fights inter se, if people fight inter se, if husband and wife fight inter se, the world can watch. It is as easily available as is your any good family program or web series. As easy as that, to search for live court proceedings. And a small request for all those channels who cut paste videos of court live streamings. I believe all our advocate friends here, brothers here, have come across channels who cut paste the video from the court and put up on their channels. Now, a gentle request for all of them that there is a violation of copyright of the concerned High Court from where this data comes. As per the Gujarat High Court rules 2021, this is not permissible. But many channels do it, many people do it, and many people watch it also. But that's not the subject of today. But the only comparison I'm trying to draw is that all of those court proceedings are so easily available. Per contra, if there is a mediation, then it is the duty cast upon the mediator and at the center that the names of the parties, the identity of the parties, the nature in dispute is not supposed to be disclosed, especially when the matter is ongoing. So far as the matter is settled, then it becomes a landmark. Then it becomes a landmark, because then it becomes an example for the coming generation, for the generation who is litigating, for the people who are wasting their time in litigation. Now, I'm not meaning this in the sarcastic way, wasting their time in litigation, but compared to mediation where result is in front of you, it's a matter of demand and supply. As easy as that. But in litigation, having the same result is, I would not say impossible, but very difficult. Moving on to the next aspect, narrate your story and be heard. Now, there are, I believe all our brother advocates, sisters here, brothers here have come across this, where they have to tell their client that those control, this is not something we can write in our complaint or affidavit or plaint or written statement or petition. Right? As I am reminded of one of my conversation with my client, where my client being the wife, she said that, sir, मेरे ससुराल में तो दाल भी बराबर नहीं बनती थी. So I said, Ben, ये हम लिख नहीं सकते. We cannot write this in your complaint. This may be a factual aspect, but this is something which can be part of your testimony at the time of trial, not a part of your complaint as an averment. So she felt really offended with this. कि सर आपको ये इतनी छोटी बात लगती है? मैं बोला नहीं बेटा, ये छोटी बात नहीं लगती है मुझे पर्सनली, चलो नहीं लगती होगी, एग्रीड, ये मुझे छोटी बात नहीं लगती, बट कंप्लेन में ये लिखना आपकी कंप्लेन में वो एवरमेंट नहीं देता जो कंप्लेन में होना चाहिए. This is a wasteful line in your complaint or in your written statement. So we'll have to approach it legally. We have to draft it legally. We cannot, adopt your narration and then put it up in our, because ultimately coming back to drafting and professional ethics, as a lawyer, we cannot sign, it is our pleading. We sign the pleading. The party only puts his affidavit. Ultimately, it is Paras Sukhwani's petition or Mr. Shah's petition. Ultimately, it is coming from our office. So we are responsible for the averments that we put legally. Of course, his version of things, we can translate and assist him putting in the plaint or in the written statement. But we have to tell him or her that you will have to control yourself. Sometimes it goes well, sometimes it doesn't go well. And for the times when it doesn't go well, they feel offended. कि हमारी बात कहवानी भी तक ना मरे, because it's process. There is procedural laws which take care of everything. But in mediation, they have full right title over their own cause, their own case. They may say whatever they wish to. They may agitate whatever grievance they want. Of course, if it brings a solution, or of course, if it is part of the problem. With that being said, moving on to the next, no judges, no juries, no decision. Now, this art of mediation or this beautiful aspect of mediation is that sometimes it so happens that I had one friend in my law college who would be excellent in preparation. While he's preparing his case, while he's preparing his narration, he's absolutely excellent. But make him stand before a judge and he's nervous. So I one day asked him that, what makes you so nervous? Tari taiyari atli sari she, you have been reading whole night, now you are fully prepared, you have sections on your fingertips, then why are you so frightened before the judge? And the answer lied in his simple one line, Judge sahab thi veek lage chhe. I said, why be nervous? But I don't like being judged, so I don't like the judge. That was his simple reply. I said, but given the preparation you have and given the talent which I see in you, you are bound to succeed. Na, judge sahab same to nathi aavtu yaar. I said, okay, no problem. Now, mediation takes care of this aspect very well because nobody is going to judge you. Nobody is going to say, in mediation especially, कि तुम्हारी आवाज सच्ची की ये बात खोटी. Demand, negotiation, settlement, all these are different aspects of the matter. All this is a stage where you have already arrived at a consensus with the other side. But so far as your narration is concerned, nobody can say कि आ तारो narration odious है. Nobody can say that. In the court, yes. In the court, the honorable judge is well within his rights to say that I don't accept this defense. I don't like this defense. For example, we have seen in many contempt jurisdiction matters where the honorable government lawyer must have said that, sir, we could not comply this order because of this or because of that. So the court may say that coming from government, this response that you could not do this because of this or because of that is not appreciated. You are the mighty government. You are the mighty corporation. You have to be on time. You have to be particular. You have to be punctual, right? Now that aspect, mediation takes care in as much as there's no juries. Nobody can say कि तुम्हारी आवाज सच्ची कि ये बात खोटी. मांगो. Ask for the Taj Mahal and it may be given to you. We don't know. But that free rope or that free narration of a client's mind is something which the mediation permits. Now that is an aspect which takes me to another aspect of mediation, which is that in future or in the coming part of litigation to encounter pendency, what should be the approach? In my respectful say, I see Section 89 as one of the beautiful pieces of legislature which leaves it on the court as to the discretion of what can be sent to an alternative dispute resolution process. Now, many times in the past also, we must learn from the past in as much as we have some distinct jury members, some distinct judges who have said that I trust the two of you counsels, go outside, have a word, come back, and I will prevail upon the parties that this is how the settlement can take its form. Or this is how I see that there can be a settlement. With that being said, I read a few lines for mediation and conciliation, which are taken from a beautiful piece of legislature by His Lordship's Justice A.K. Sikri of the Honorable Supreme Court. His Lordships, in the case of Vikram Bakshi and others, have said mediation being a form of alternative dispute resolution is a shift from adversarial litigation. When the parties desire an ongoing relationship, mediation can build and improve their relationships. To preserve, develop, and improve communication, build bridges of understanding, find out options for settlement for mutual gains, search unobvious from obvious, unearth a problem, and dig out underlying interests of the disputing parties, preserve and maintain relationships, and collaborative problem solving are some of the fundamental advantages of mediation. Even in those cases where relationships have turned bitter, mediation has been able to produce positive outcomes, restoring the peace and amenity between the parties. There is always a difference between winning a case and seeking solution. Via mediation, the parties will become partners in the solution rather than partners in problem. The beauty of settlement through mediation is that it may bring about a solution which may not only be to the satisfaction of the parties and therefore create a win-win situation. The outcome which cannot be achieved by means of judicial adjudication, thus life as well as relationship goes on with mediation for all the parties concerned and thus resulting into peace and harmony in the society. While providing satisfaction to the litigants, it also solves the problem of delay in our system and further contributes towards economic, commercial, and financial growth and development of the country. This bench is of the firm opinion that mediation is the new dimension of access to justice, as it is one of the best forms, if not the best, of conflict resolution. The concept of justice in mediation is advanced in the overviews of Professors Slutberg, Love, Heyman, and Medio. Their definition of justice is drawn primarily from the exercise of party self-determination. They are hopeful about the magic that can occur when people open up honestly and empathetically about their needs and fears in uninhibited private discussion. And as thinkers, these jurists are optimists that the magnanimity of the human spirit can conquer structural imbalances and resource constraint. Now, we find the place for mediation not only in Civil Procedure Code, but also in Section 14, Subsection 2 of the Hindu Marriage Act and Section 29, Subsection 2 of the Special Marriage Act, as well as in Order 32A of the Civil Procedure Code, as well as in Rules 3 and 4 of Order 32A. With that being said, the Honorable Supreme Court also in this judgment has not only praised mediation, but has recommended mediation in matters where decision making may not be possible by leading of evidence or by traditional methods of judicial adjudication. Now, I may discuss a small aspect of a situation of a man. Of course, I begin this by saying on the lighter side, because this is an aspect when I discuss, people normally have a wide smile on their face. So I begin by saying on the lighter side. See, the man or the human, the man, the male side of things, for the female sitting here will understand it better. The male side of things is the most innocent creature on earth. If you ask why, then I may tell you. Because is male side of creature ka kuch bhi khud ka nahi hai. There is nothing which by himself the male does. Want to understand how? If he listens to his mother, Mavadiyo. If he listens to his wife, Joruga Gulam. If he listens to his father, Naukar. So all these are aspects which make a man. Now, of course, I began by saying on the lighter side, but this draws us to a very serious conflict which was recently solved by the Honorable Supreme Court from the voice of His Lordship Justice D.Y. Chandrachud. And the conflict was when Maintenance and Welfare of Parents and Senior Citizens Act is on one side and the Domestic Violence Act is on the other side. What law should prevail? Now, in the beginning, when I started the address on mediation, I had made it very clear that no book, no law can teach you how to live peacefully. It can only show you, so far as adjudication is concerned, the way out. Like, for example, if there is a conflict between a family, the Transfer of Property Act or the revenue records can only show who is the owner of the property. It cannot show how peacefully in one house can a family stay. With that being said, the facts of that case were very peculiar in as much as in order to create a shield for the husband had roped in the Maintenance and Welfare of Parents and Senior Citizens Act, and he said that I have responsibility towards my parents also. I have responsibility towards the wife also. Which responsibility shall prevail when the question of this particular dilemma comes to? The Honorable Supreme Court clarified the situation, and again, mediation played a very vital role. Mediation, like we just discussed, showed the parties as to how a dispute resolution process can help, a dispute resolution process so dynamic, which can help the parties to understand their loss and their benefit. And with this feeling, I move on to the concluding address, and I feel that the ADR, or the alternative dispute resolution, is actually the future which can take litigation to another scenario. With that being said, I would only quote, I would only quote a shairi which I have learned, or I have experienced, or I have lived in the recent past, or in the recent of my life. I have lived this, that आज तक जो हुआ उसे भुला देना है, आज तक जो हुआ उसे भुला देना है, ये तय है कि दुश्मन को दुआ देना है, आज तक जो हुआ उसे भुला देना है, ये तय है कि दुश्मन को दुआ देना है, ऐ मेरे यार आजा लग जा गले, फिर कभी देखेंगे क्या लेना है क्या देना है. Right. With that being said, I end my address for today. I thank our President Shri Kartikeya ji, the Honorable Secretary, the Vice President Sir Shri Patel ji, Shri Sridhar ji. I thank you, all of you, for having me here. I feel really grateful and honored to be part of this beautiful August gathering. And if there is anything I can assist you people with, I would be delighted to help.
Thank you so much, Paras ji. Let me tell you the fact that I have never seen a lawyer with such a smiling face. Your entire speech, you remain smiling and you remain so positive. So I am very much sure that whoever comes to you will always remain happy forever after. And in arbitration and mediation process, there is always settlement. So for that, this attitude always will win. And sir, let me tell you again the fact that it was an extraordinary speech, because now our tax professionals must know the allied laws, and that's why we have started this campaign in this year, that they should be aware about the allied laws, because now in tax professionals, allied laws are also incorporating, and they must be in need of this knowledge. I must thank Ashish ji to bring you.
If you give me that opportunity, a special vote of thanks to Shri Ashish Bhai Tekwani for having me here. I request him that if in the future also, if you can give us beautiful opportunities like this, we'll be happy to help.
It's my pleasure to have you, and thank you, Kartik Bhai, for giving me this opportunity to bring young and dynamic speaker for our association. And on a side note, we know each other since we were, I think, not even in school, maybe we can say. So it's our pleasure, my pleasure, to see him give such a wonderful speech in presence of such a august gathering.
And sir, last thing, that you not only explained the procedures, laws about arbitration, mediation, but you have also brought the reality on the platter with case laws, with the real cases you have fought in different high courts. So it was really interesting. Now I request Honorable Secretary of Income Tax Bar Association, CA Sridhar Shah, to please give certificate of appreciation to our honorable faculty.
Sir, please accept.
And also give vote of thanks, Sridhar bhai.
So it's a pleasure to propose a vote of thanks for such a wonderful webinar, which was Paras bhai, I must say that listening to you was a pleasure. It was so fluent and so much that I could not move an inch from my place, because it was, number one, it was wonderful, it was knowledge worthy, and it had all the contents. Like, you had a shairi or quotes in between, you quoted the judges, and also it went in such a manner that, yes, definitely whoever has listened to it fully, they must appreciate the way it was told. And also we thank Ashish for bringing you here on this platform. Also, we'll wish that to have you on our platform again and again. I would like to thank you for giving such a wonderful lecture, and also thank all the members of both the associations for participating in the webinar. I would like to also intimate the members about the upcoming programs. We are having 2 programs in pipeline. On 21st, we have a webinar on Government of Gujarat subsidy assistance to the industries, which is again a program in allied laws, and subsidies becoming an important part from the government side to promote the industries and towards our 5 trillion target. On 23rd, we have a webinar. On Thursday, we have a webinar on how to handle GST scrutiny, and we'll having a guest speaker, Abhishek Rajaram, who is a nationwide known faculty. So all the members are requested to book your calendar and join the webinars and be benefited from the same. Thank you. With this, we end this webinar. Thank you all.
Sir. Thank you, sir. Thank you so much.